Good morning or good afternoon, depending on where you're joining us for today. We have folks from all over the globe, and we appreciate you being here. On behalf of Ethisphere, my name is Chelsea Camella, and it is my pleasure to welcome you to today's presentation of Safe Harbor webinars, Data Protection Updates, Safe Harbor, and the Practical Impact for Companies. There are a few logistical items I'd like to address before we begin today's session. We encourage you to engage in the question and answer portion of today's webcast by using the chat function that's located within your viewing experience. The presenters will reserve time at the end of today's webcast to address as many questions as they can. If we do run out of time, we will follow up via email thereafter. Following the live webcast, we will provide you with an email with access to the recording along with the presentation materials. We are very pleased to partner with Field CIS on today's webcast and like to introduce you today your presenters, which include Robert Bond, Dennis Heist, and Michael Spee. With all that said, I'd like to now turn the floor over to Dennis to begin today's webcast. So Dennis, you may now begin.
Thank you, Chelsea. Today for this important and rapidly developing topic, we have assembled a panel consisting not only of a recognized expert on data protection and cybersecurity, Robert, but also Michael, an EU-based representative from a multinational data controller, Johnson Controls. I represent two U.S.-based data processors, one being Steel, a due diligence service provider, and the other being Securamate, a third-party management software solution having dedicated servers in the United States. We hope to provide you with basic background information and expert insights on the state of EU to U.S. personal data transfers, and how data controllers and data processors are reacting to the uncertainty created by the Schrems decision, which invalidated Safe Harbor, followed by Tuesday's announcement of a political solution which is being referred to as the Privacy Shield Framework. The topics of discussion are listed on the following slide. After Tuesday's announcement of the Privacy Shield Framework, the panel contemplated a change in focus. But ultimately, we felt that given the work that remains to be done on the framework and the skepticism that data protection authorities may have as the details are announced, that it would be useful for our audience to have the full background and context leading to the Schrems decision, while certainly saving time to fully explore what we know about the Privacy Shield Framework. Therefore, our topics are the full range of data transfer solutions, data protection notifications, filings, and registrations, a summary of the significant rulings contained in Schrems versus Data Commissioner, the Article 29 Working Party activities following the Schrems decision, the likelihood of completion and acceptance of a EU-US Privacy Shield framework and how it might differ from Safe Harbor, and finally, the generally accepted alternative mechanisms for data transfer. In terms of understanding data transfer solutions, Robert, could you please walk our audience through the various data transfer solutions depicted on the clock face diagram?
Privacy applies in the UK if the UK company can self-audit itself as to the protections it gives to individuals. Just at the 6 o'clock, there should be the words on this slide here, countries approved by the EU, and there are countries like Argentina and Israel and some smaller countries approved for data transfers, but the vast majority are not. It's perfectly permissible to transfer data without consent if it's a contractual necessity because you're doing a deal with a particular individual to sell them something. And then we come round to model clauses, which seems to be one of the routes that we're all having to go right now, absent Safe Harbor. And these are approved model clauses to provide for situations where data is being transferred from a controller in Europe to another controller outside Europe, or from a controller in Europe to somebody like Dennis's Steel, who are a processor outside Europe. What we don't have across Europe yet, but which is anticipated in the future, will be the ideal of seals or trust marks, where EU affiliates and entities might submit themselves to the relevant regulator in their country for an audit to see that they comply with appropriate standards, after which they get a trust mark which says trust us and trust us to deal with your data safely when it's transferred from Europe to somewhere else and then back to the top. As Dennis said, and we'll come back to talking this in more detail, we had Safe Harbor as a unique data transfer solution between the EU and incidentally Switzerland and the US, but the decision back in October last year to strike it down was made by the European Court of Justice. And in the absence of Safe Harbor, we've had this hiatus where businesses have been trying to find a different solution if they relied on Safe Harbor. And as at the beginning of this week, Safe Harbor 2, or more properly the Privacy Shield, is the political solution that's been reached, though it still isn't yet the legal solution. Does that cover that, Dennis?
Yes, but can you tell me what misconceptions have you seen with regard to the original Safe Harbor?
So when that original Safe Harbor was negotiated some years back, it was between the European Commission on the one hand and the Department of Commerce on the other, in relation to those businesses that the Department of Commerce regulates. It's therefore always been the case that the banking and financial services sector, including insurance, and indeed the telecom sector, which have never been regulated by the Department of Commerce / Federal Trade Commission, they've never had the benefit of Safe Harbor in the first place and have always had to find some other solution like consent or model clauses or binding corporate rules. So I think when the Safe Harbor was struck down and there was quite a lot of media, if not business reaction to this is the end of the world for data transfers, it wasn't and it isn't, because there was already several sectors that were never relied on it anyway. There's also been a perception that this is a US certification only, and that if a US company has self-certified to be Safe Harbor compliant, then it is perfectly acceptable for it to receive data from an EU affiliate or an EU business. To a certain extent, it is correct, it can receive it. But when you look at it from a European legal perspective, the issue is with the exporting entity in Europe that may not be in a position to export under Safe Harbor because of some localization law, or because the US company was certified for Safe Harbor, but not necessarily for the country in Europe from where the data is being exported, or not necessarily for the classes of use of data that the company is self-certified for. So it's much more complicated than there was Safe Harbor and now there isn't.
Thank you for that clarification. Given that we have audience members from outside the U.S., could you briefly walk us through the flow chart of data export under Safe Harbor or Privacy Shield and these other methods, Robert?
Absolutely, and this is quite a complex flow chart, but what we've got at the top is if a business is looking to export personal data, and remember this only applies to personally identifiable information, not non-identifiable or information. The questions you would need to ask yourself is, well, is the data being exported within the European Economic Area, which I described earlier? And if it is, then within the EEA, intra-EEA transfers are permissible. So then we jump to the other side of the slide, and the question is it going outside the EEA? And the answer is yes. Then you need to decide, well, where's it going? If it's going to the approved countries, and I've listed them here: Argentina, Channel Islands, Switzerland, Faroe Islands, somewhere up near the Arctic, Israel, Uruguay, and New Zealand, then those are approved by the European Commission, and we expect other countries to be added to the list in due course. And you don't need anything else because Europe has deemed those countries to have the right protections. There is a specific issue in relation to Canada in that certain aspects of personal data are permissible. For the US, of course, we've just talked about Safe Harbor and Privacy Shield, and I've put this in red because we have a problem. Absent Safe Harbor and Privacy Shield, if it's going to the US, you have to find some other solution, and you'll see that we've dropped down there to choices 1, 2, 3, and 4. And again, if those choices are not achievable, then you have to ask yourself, can we have adequacy presumed? And that would only apply from the UK to the US, in which case the answer is no, you can't transfer it. If it was the UK, yes, you can. And then for everywhere else in the world, you have no choice but to drop down to those 4 questions to go through. And again, if you can't presume adequacy because you're not transferring from the UK, you have to fall back on model clauses, binding corporate rules, an approved privacy contract on a one-off negotiated, or maybe some of the other grounds like consent or contractual adequacy. Dennis?
Thank you. For the data controllers in the audience, can you cover the issue of data protection notifications, filings, and registrations? Michael and Robert?
I'm happy to start this one off, and then by all means, Michael, add in if there's more or I've missed something. We have this notion in Europe which does not exist in the US and indeed in some other parts of the world, that if you are what we call a data controller, namely you're a business that makes decisions in relation to people's data, in most countries you have to not only have in place the policies and procedures and the contractual mechanisms to deal with data transfer, but you have to register or notify or file, whichever word you want to use, your existence as a data controller, a description of the types of data that are being transferred, the reasons why, the recipients, what security procedures you have in place. And this has to be done in many countries before you even start to transfer the data. In some countries like the UK, it's a templated exercise. In France, for example, it's very paper-based. And in some countries, you shouldn't be doing the transfer until you have had permission or license from the regulator, which often applies in countries like Portugal and Spain. This means it's much more than a tick-the-box exercise, and there are different types of notifications that exist. But specifically, there is one in some countries just for the mechanism that's being used to deal with the transfer of personal data. So even if you are safe harbor or were safe harbor, you still had to notify the French regulator that you were transferring personal data from France to US and prove the mechanism by which you were doing it. And there have been a good number of multinationals that have gone through the contractual mechanisms or filed for safe harbor, or who may well think that the Privacy Shield is another mere process that will forget that failing to notify is in many cases an investigatable offence. Hence the reason I flagged this one up.
Mm-hmm. Yeah,
Michael, what's been your experience?
Yeah. So, yeah, indeed, quite an effort-intensive exercise as a data controller and speaking for a multinational company with global presence. So we do have a lot of activities related to the maintenance of those notifications in all of the EU member states. And by the way, I'd like to also mention that similar registration requirements exist in countries outside of the EU. But so the way it's implemented by the national data protection authorities is kind of varying, as Dennis just explained also, because what you see is some countries where the level of details of the registration is quite high level, like in the UK, where basically what you have to do is to notify to the authorities your existence as a company and describe at a high level your processing activities, but that's basically it. In other countries, you may also benefit from exemptions of notification for certain types of processing. This is also, for example, in Germany, you don't have a registration obligation if you have data privacy officers in place, provided that actually they are then responsible for maintaining your inventory of processing activities. And in other countries, like you mentioned, France, it's actually much more detailed, and they really have a very structured approach to the notification with predefined standard notifications that you can apply for. So really the level of implementation in the countries varies, and well, it can be either high level or it can be just much more detailed. But this is an important aspect of the maintenance of a privacy program, indeed.
Moving on to Schrems versus data protection commissioners. Robert, can you summarize the Schrems decision that brought us to this topic in the first place, the background of the appeal and the significant findings of the court?
Yeah, sure. So Maximilian Schrems was, I think, in the midst of doing his PhD at university when he exercised his right as an Austrian citizen to find out from Facebook what data Facebook had about him, and was presented eventually with pages and pages and pages and pages of all of the different instances where his data was being collected, processed, etc., etc. And post the Edward Snowden revelations, Max decided to question Facebook about the extent to which his personal data was being shared with three-letter agencies and others beyond the scope of any international data transfer arrangement that there might have been between Facebook in the US and the relevant regulators in the EU. Max, obviously being in Austria, tried to get some reparation or assistance from the Austrian courts, but the matter ended up being directed towards the regulator in Ireland, because Facebook's argument was that as an American company, its data controller in the EU was based in Ireland, where it had chosen for a variety of purposes to locate, and therefore only Irish law and only the Irish Data Privacy Commissioner would be appropriate to adjudicate if Facebook's approach to disclosing information to Max Schrems was lawful or otherwise. the Irish commissioner didn't, in the view of Mr. Schrems, respond in the way that Mr. Schrems was expecting, and therefore he, in the end, with the support of a lot of private money, took the case to the courts, to the Irish courts, who in turn referred it up to the European Court of Justice to decide on the applicability of what law, what member state here, and whether Facebook was correct or not in its approach, and indeed whether the Irish Commissioner was acting in or not in accordance with his obligations under Irish data protection laws. And so what you've got here on this slide is the significant findings of the court. And I don't know whether, Dennis, you want to comment further on those, since I've done the sort of historical background.
Well, the decision that the United States provides an adequate level of protection was decision 2000/250, and that basically is safe harbor. But the court said that the Commission never did determine that the United States ensures adequate levels of protection by reason of its domestic laws or international commitments. And it said that an adequate level of protection must require the third country to ensure by its domestic law or international commitments a level of protection of fundamental rights and freedoms essentially equivalent to that guaranteed by the EU. So in the end, the court basically said that the decision by the Commission 2000/250 fails to comply with the requirements of the Data Protection Directive and is accordingly invalid. They didn't come out and say safe harbor was invalid, but they said that the finding that the U.S. provides an adequate level of protection through the safe harbor framework is invalid. Just to clarify, Robert, was the U.S.-EU safe harbor affected by Schrems at all?
Yes, sure. I mean, the end result of the Schrems case was that then the regulators in Europe felt that both the Swiss, or rather first it was the EU-US safe harbor, therefore couldn't be relied upon as a mechanism, because there has never been an ability for a European citizen to take the benefit of safe harbor in terms of bringing an action in the US. And I think one of the deep-seated political issues that's been driving this is that whilst there is no doubt the US has got some incredibly detailed sectoral approach to privacy, the US laws only benefit generally US citizens, whereas the EU data protection law, right or wrong in terms of its bureaucracy, benefits any citizen anywhere in the world whose data is being processed by an EU data controller. So it's those two big differences that I think has driven a lot of the reaction over the past few years, or concerns over the past few years, and safe harbor was already up for review at the same time as this was happening anyway.
So in your view, was this decision unexpected, or as an expert, did you expect it? And Michael, did you expect this decision to come down the way it did?
From a lawyer's... Oh, sorry, Michael, you carry on. Yeah.
Yeah, I was going to say, well, I mean, it was not an absolute surprise in the sense that the safe harbor mechanism in itself was criticized by national data protection authorities in Europe since quite some time, with criticism about the lack of enforcement from the FTC, criticism about a certain number of principles from the framework itself, from the safe harbor framework itself, like, for example, the concept of onward transfers to non-certified companies. There were a certain number of criticisms already existing in the past, so it was not an absolute surprise. But I think it's kind of a collateral from the Schrems actions somehow, because when you think about the prime target of his action was really about pointing at a certain number of social media companies that according to him are not protecting properly his data and really thinking about companies that massively process consumer information or citizen information. But here, the collateral of the invalidation of the adequacy finding of the safe harbor framework led to all of the companies being without a legal basis for transferring certain types of data, like their HR data, for instance, to their U.S. headquarter company. So that is something that I don't think was kind of the prime target of Schrems' action. However, with the invalidation of safe harbor, this is where it led everyone to.
In terms of initial reactions after Schrems, I can say that as data processing, representing data processing companies here in the United States, we saw an initial flurry of inquiries to our client directors in the weeks following the Schrems decision. So both Steel Compliance and Investigation Services and our SecureMate software company offered to negotiate data transfer agreements based upon the model clauses, but we sort of saw that initial flurry of inquiries die down, and really we only received inquiries from probably less than 20% of our clients, which is a substantial client base of multinationals processing data. How about your view, Michael, on data controllers? What are your fellow data controllers' reactions been? Have they basically taken the view that there's probably going to be a solution worked out, or have they all moved to implement one of the other data transfer mechanisms?
Yeah, well, I think that the option of wait and see is not really in the books. So what I see around is and just like what we do at Johnson Controls, is we actively try to implement alternative adequacy mechanism with our service providers. So, namely implementation of standard contractual clauses. And this is because of the reason that, as you know, the Article 29 Working Party set a clear deadline of January 31st to start enforcement action for against companies for transfers which still relied on the invalidated safe harbor adequacy finding. And so we see, because we have entered into a lot of contract negotiation with vendors, and we see all the vendors mainly used to the process now of transitioning their customer base to standard contractual clause. Now, the beauty of standard contractual clauses is it is somehow non-negotiable, right? I mean, so it's not like you can alter the terms of those standard contractual clauses. Otherwise, they become modified clauses, which require also and ex ante approval from the data protection authorities. What I mean here is what we see around is everyone jumping on standard contractual clause. But when you think about really the findings of the European Court of Justice and the two, I would say, key reasons why they came to the invalidation of safe harbor, that was really about, first of all, these allegations of massive surveillance practices, so not respecting proportionality principles. And then the other aspect was the lack of judicial redress. Now, when you think about those key elements, those are true irrespective of which adequacy mechanism you use for transferring data to the U.S. This is why there is still, some limbo here for all the companies awaiting for the Article 29 Working Party to make a final determination, not only about whether the new EU-US Privacy Shield now meets the requirements of the EU data protection standards, but also all of the other transfer mechanisms such as standard contractual clauses and BCR. Now, I suspect that the guarantees that are provided under the new negotiation between the EU and the US cover for those requirements of the judicial redress as well as standards for practices around surveillance and respective proportionality principles. So I think with those two elements hopefully covered, then I would expect that there will be a positive position from the Article 29 Working Party. And I know that this was a question I've seen popping up here. So this is our expectation.
Robert, what's your view on what's left to be done, what we don't know about the commitments that the United States is prepared to make, and just how far away we are from this Privacy Shield framework taking shape and being in a position where the Article 29 Working Party can look at it?
Yeah, thank you, Dennis. Picking up on some of the comments Michael's made, I have to say that the decision, of the European Court of Justice might well have been made on very good legal grounds, but the domino effect of that has been that it does put into question all of the mechanisms if the real reason behind this was surveillance for national security or other purposes. So as Michael says, I think it brings into questions all of the formulas that are being used. That being said, the fact that there has been movement by the U.S. in terms of the Judicial Redress Act, the fact that the announcements of the closer cooperation between the FTC and the European Commission for Enforcement, which actually has been quietly going on in the past anyway, for the last year or more, and the idea of regular ombudsman to oversee the principles of Privacy Shield are all great. What I think has got to be done by the Article 29 Data Protection Working Party, which is in effect the college of all of the member state regulators, is to find a balancing act between what we know has got to happen in terms of national security, and on the other hand, an ability for businesses that generally want to be compliant to be able to transfer data, because unfortunately that is the way the world works. Data doesn't go in boxes from UK to the US anymore. That happened 30 years ago. Data goes every which way, and to be constantly focusing on EU-US makes a mockery of the general digital world that we live in. And so I'm hoping that over this next few weeks, according to the Article 29 Working Party, they are going to use this period of February to focus on the practical rollout of Privacy Shield. And assuming that they can dot the I's and cross the T's, then what we then want is to see how does it look in practice in terms of what we understand as the safe harbor list, Will there be an equivalent? What happens to everybody who was safe harbor certified? Does that suddenly convert across? What about other countries who rely on the idea of safe harbor, like Israel? And God forbid that we start to unravel model clauses and binding corporate rules, because that's all that is left. And it's certainly what's anticipated not only by the new EU regulation that's coming along, but frankly there are many other parts of the world like Southeast Asia, the APEC communities, where the concepts of BCR and model group contracts are already accepted as a suitable mechanism for data movement within the APEC communities. So I think it will be madness if we don't find some solution. I'm not sure how much of a fudge it will be, but there has to be one. It's too much at risk.
Well, in terms of the Judicial Redress Act, for those who are not familiar with it, it's designed to provide judicial redress to European data subjects who, in the United States, being able to sue in the United States and U.S. courts. However, it's bottled up in the Senate. It's passed the House of Representatives, and it's in the Senate committee. But it allows the Department of Justice to designate which U.S. agencies would be able to be sued for privacy violations, which I don't know how the Europeans will react to that, but it would be interesting to see whether the Department of Justice designates the National Security Agency as an agency that's able to be sued by a European data subject. As you mentioned, data processing contracts based on the model clauses are very important, and Michael, as a data controller, is moving to those. So, Robert, can you take us through this slide on data processing contracts?
Sure, and then obviously I know Michael has a lot of experience of this in practice, being in-house. But when from an EU perspective, a data controller outsources management of personal data, whether it be to a Salesforce or to a Securimate or a Steel, we do have, again, under EU law and the member states' equivalents, a requirement that since the data controller is primarily liable for the activities of the data processor, there has to be considerable due diligence done on what or how the data processor is going to manage the controller's obligations. And that may be due diligence about the physical location of the data center. It may be on the insurance that's being carried. It may be on the quality of the staff that are being employed to work on the research and analytics or hosting or whatever. And certainly the regulators require contractual controls to be put in place. And again, there are specifically approved model clauses or model contracts for where there is a controller in Europe exporting its data to a processor and or then on to a sub-processor outside Europe. And these are mandated contracts, again, like Michael says, really not negotiable, because then they're not model contracts. Now, to be fair, safe harbor was always a possibility of being relied upon where the processor was safe harbor certified, and I can think of many, many businesses that use that route, which is of course why there has been this panic that you described, Dennis, in the first few days, if not weeks, after the Schrems, etc. decision. But again, don't forget that where you appoint third parties, many, again, of the EU regulators will require the existence of the contractual relationship to be notified or filed with particular regulators, and often that's not been considered and would have applied were safe harbor still to be in place. And we still have this historical issue in Europe that when you do notify a regulator of the transfer of sensitive data, even where it's within an HR context to a third-party host, there are some data protection authorities that cannot get their head round why sensitive data would ever leave their member states. And that has caused lots of challenges for multinationals, as no doubt Michael would be able to tell us.
Yeah, absolutely. So, and I see lots of interesting questions popping up here. Like, for example, there is one here talking about a parent U.S. company that has EU affiliates and who is, who has to actually file with the data protection authorities and do this registration. So clearly, the data controller is the affiliate in the EU that is exporting the data to its headquarter company in the U.S. in this case. And one of the things that I'd like to clarify as well, which is quite important, certainly if you are a data controller with a complex corporate structure, is that those obligations typically apply down to individual legal entities. So if you have like 20, 30 legal entities in a specific country, you have to understand that these notifications have to be done down to individual legal entities. Same thing when it comes to executing these standard contractual clauses. One of the things I'd like to clarify as well is that, as we said, the difficulty is not so much in the negotiation that you may have with the data processors about the clauses themselves, because you're talking about a model contract, so you cannot really alter the clauses, without taking the risk that the contract loses its adequacy somehow. But it's more about considering that when you have an agreement with a third-party vendor, typically what happens is that you have multiple agreements with multiple statement of works, which are actually involving not only on your side a complexity of legal entities as the data exporters in the EU, but also a complexity of involved importers on the side of the vendor, because some of your vendors may process the data within some processing centers or multiple processing centers in the US, but also in other places in the world. So when you execute those standard contractual clauses, quite immediately the complexity of the execution to describe the processing and to describe the parties of the contract can be quite quickly going very complex. So that is why it is not a simple exercise, and it takes time to effectively engage with all of the vendors and execute those standard contractual clauses. And therefore, the deadline of January 31st and giving somehow a 3-month time frame to the companies to adjust to migrate to standard contractual clause is, to some respect, quite not realistic. So that is one element I wanted to mention. Another element I wanted to also talk about is when I see here questions about transfers of HR data from EU affiliates to parent entities in the US for HR purpose or administrative purpose, and whether that falls under the scope here. Well, the answer is quite obviously yes. It falls under the scope of the directive, and it falls under the scope of the adequacy requirements. Now, speaking for Johnson Controls, as you may have heard in the beginning of the session here, so we are a binding corporate rules company. So we went through all of the filing process, the approval process with data protection authorities, and so we rely on our binding corporate rules to transfer our data inside the group of Johnson Controls. But that does not put us completely away from what happens now with the invalidation of safe harbor, to the extent that, again, binding corporate rules are only for your intra-group data transfers. But whenever you actually engage with a third-party vendor for the hosting of your personal data, for HR systems, for IT systems, whatever, or when you use systems which are like software as a service, so externally hosted services, well, immediately you fall into that question about where is the data hosted, and if it's in the US and it's usually relied on safe harbor, well, these are the vendors that you have to contact to migrate to standard contractual clauses. So those are the points which I think were kind of important to mention in reply to some of the question I see popping up there.
We can take some more questions. I just had a couple of comments on model clauses from the data processor viewpoint. As long as the model clause, and by the way, there are two sets of model clauses. There are the original model clauses that came out in 2001 and the updated versions that you should be using, which came out in 2010. But if the standard model clauses are used, it's not a painful process. Appendix 1 has to be completed in terms of what is being processed by the control, what is being controlled by the controller, and what is being processed by the processor, and how it's being processed. And then Appendix 2, which is the administrative and technical security measures. As long as you use the model clauses, it's not very difficult. But we have seen people that come in with 10-page versions of that, which supersede the model clauses and go into very great detail about things like passwords and how long they have to be and how they have to be changed and other technical measures to protect data. We also see clients that come in with pages and pages and pages of unique country additions to the model clauses, which is can draw out the negotiations while you review all those. So in terms of questions, I'll throw these questions out. What exactly is non-identifiable information? Could you provide some follow-up on the distinction between identifiable and non-identifiable? Robert, you want to tackle that one?
Yes, I think it was me who used that phraseology at the beginning. From an EU perspective, we define personal data as being information which identifies a living individual from that information or from other information which is or is likely to be in the possession of the data controller. That sometimes means it's quite clear if I've got somebody's business card, it is personal data. Several regulators have said IP addresses are personal data. What becomes more interesting is if you try to de-identify the individual by encryption in some form or by aggregating data, or you have fairly benign personal data and then you use coding within, say, the HR department where everybody knows what the coding means in terms of the career progression or otherwise of the individual. In itself, that coding is not personal data, but then when you attach the two together, the law says this is all personal data and the individual has rights to see it. When you encrypt personal data, there's an argument that because it's scrambled, it's non-identifiable, therefore the law does not apply because it is not personal data. Again, many regulators take the view that, well, in a business scenario, the chances are that the key to decrypt is in the possession of the receiving party, and therefore it's still personal data, therefore all the usual law applies. And we've seen in the clinical trial sector and the healthcare sector and so on, attempts to pseudonymize, anonymize, de-identify, and again there's massive academic argument about is anything really really non-identifiable in the current climate. And the safe route for most compliant businesses is to attempt to comply with personal data laws rather than try and find technical ways around it. But that doesn't mean that you shouldn't use things like encryption to keep data as secure as you can.
I think we've talked around the next question, but I'll throw it out there. How likely is it that the Article 29 Working Party will issue a positive statement? What do you think needs to happen with Privacy Shield so that the European Court of Justice will not invalidate it again? Robert, that's probably in your ball court.
Oh, I was hoping you were going to give it to Michael.
Yeah,
maybe Michael has.
Sorry.
Go on, Michael. Save me.
Okay, no. Well, I would just, I just reiterate some of the topics that we talked about already. I think, first of all, they want to see, how binding the new agreement is, and they want to see that on paper. And I think for now they only have seen press releases and high-level statements. So it's a political statement at this stage. So I think that the data protection authorities want to go beyond that. Second thing is they want to really understand the details of the Judicial Redress Act and what that brings in terms of guarantees of the right of redress for EU data subjects. And then, again, quite importantly, is this mechanism of agreeing on proportionality principles for surveillance practices. And I think that what one of the important aspects of the political deal at this stage that you can see into the Jourova statement, so the commissioner, is that they intend for this framework to become much more of a living framework where there will be continuous alignment as opposed to kind of a one-time agreement that lasts for 15 years without being revisited. And I think that this is really a very important aspect. There is also another element that was stated. It's the fact that there will be also the creation of an ombudsman to facilitate redress for EU citizens in case of dispute. And I think that also needs to be clarified for the data protection authorities in terms of how, what's going to be the power of that ombudsman entity and how do they also keep their own power as a national data protection authority. So all of those things need to be analyzed by the data protection authorities in Article 29. But I'm quite positive that at the end of the day we will come to a solution, because as we mentioned earlier, and Robert talked about this also, getting to a no solution is just not a practical outcome. So I don't see how that would be possible. That would end up that would end up to a sort of localization law for Europe, which is just not realistic.
So from a practical standpoint, Michael, do you see a further extension of the grace period while this is all fleshed out and people can just wait?
Well, no. The statement from the Article 29 did not extend the grace period. They said now they expect all companies to have moved to alternative solution. But what they said also is that they would actually act in terms of enforcement on a case-by-case basis and also on the basis of complaints. So there is a certain level of uncertainty at the moment, and that will remain until a more final position from the Article 29, which is planned by the end of March now. Yep.
Dennis, can I just comment as well?
Sure.
The advice that I've been giving to multinationals is the longer you do nothing, when you have an incident and a regulator in Europe gets involved, you can imagine that it will get progressively worse. The fact that as a large multinational, it is going to take months to negotiate a whole range of model contracts to consider which regulators you have to notify, what notifications you have to update. Most sensible regulators would accept that argument that we are moving in the right direction. Sorry, we are not 100%, but, this is life. To have a situation where your only answer is, well, we just thought we'd wait and see, is absolutely no answer at all. So doing something has got to be the right direction, not simply waiting to see whether Privacy Shield does it or not. The bottom line is we have known since October last year that the safe harbor route was not a route. And to be at February now and still be doing nothing, I think gets dangerous every day that goes by.
Thank you.
Yeah,
I think
we
we
agree with that.
time for one more quick question. Is an IP address personal information?
It's Robert. Yes, I mean, that's been the ruling in a number of guidance, or it's been guidance from a number of the regulators in Europe, and there's also been instances where it's been made quite clear in court cases that an IP address in many circumstances is sufficient to identify the individual. Not the subject for today, but that's part of the reason why we've ended up with our parallel, cookies, e-privacy laws. Because that's precisely what's being picked up, via website cookie gift technology, is the IP address that enables you, if you wish to identify the individual for marketing purposes.
I think we're at the top of the hour and our time is up. I want to thank our panelists and thank all our audience members for attending and turn things back to Chelsea.
Thank you so much. And on behalf of Ethisphere, I would like to also thank the attendees who joined us today. And I know we experienced some technical issues during today's session, and we're following up with our provider. And we appreciate your patience and understanding and apologize again for any inconvenience it may have caused. As a reminder, we did record today's session, and the presentation materials will be sent to you via email directly in the next business day. If you have any questions, you do have my email address. Please do not hesitate to reach out. I'd also like to extend a special thanks to the folks over at Steele Compliance Investigation Services and to Robert, Dennis, and Michael for a really great presentation filled with great content. And we hope you all left this session feeling well versed with it. This webcast, as I mentioned, is available for recording along with all Ethisphere webcasts available on demand for our BELA members. Our Business Ethics Leadership Alliance members are also offered complimentary registrations to our upcoming Ethisphere Global Ethics Summit and other summits around the world, and leading into our 8th Annual Global Ethics Summit taking place on March 9th and 10th. We're very thrilled to be partnering with Steele again and highlighting their CEO, Kenneth Kurtz, on the third-party due diligence panel, Managing Risk Across Global Relationships. We'd love for you to also join us and hear more from our very robust agenda that we have, and extending a 15% discount for those of you using the code WEBCAST when registering online. If you have any other questions, please do not hesitate to reach out to me, or you can access our events calendar at ethisphere.com/events. Thank you again for joining us today, and we look forward to hosting you at our next Ethisphere event.
Thank you.